out. Just by way of introduction, I know because session information for this session doesn't have speaker name, so I'm very mysterious. But just to break it down and cut down that mystery, my name is Raman Singh Chima. I'm a lawyer and policy analyst by training. So please stay in the room, don't run away. I promise you it is going to be interesting. My full-time job, and what I'm going to talk to you about today, is a little bit about the legal and policy environment about cybersecurity, but a bit also about what's coming next. But what I'm going to just tell you about a bit is where I'm from, and then dive into what we're going to talk about. I work for a non-profit organization, an international non-profit called Access Now. I wear in fact a couple of different hats as well, and I'll talk about those. Access Now is an international non-profit org that seeks to protect and extend your human rights in the digital age, your rights to privacy, free expression, network neutrality, as well as ensuring that through all of this, because it's become so critical, that secure communications, whether it's strong encryption or whether it's robust, effective cybersecurity solutions and others, are there to focus and protect the rights of our individuals globally in this period. I worked in industry previously, my dark secret for 5 years in Google's public policy team, saw the light, and in addition to what I do at Access Now, I also helped work with India's net neutrality campaign a bit, SaveTheInternet.in. Some of you may have seen it, some of you hopefully also sent petitions, engaged with the Indian government on that topic. And I helped co-found and sit on the board of a group called the Internet Freedom Foundation, which is an Indian civil liberties organization. The running joke is, since you've heard Eva speak here, IFF seeks to be India's EFF, but do much more as well. But on topics such as effective protecting your free expression rights, but also concerns that as security researchers, you may say that your fundamental rights are being affected, I encourage you to see their website, which is internetfreedom.in, where you can also receive legal support, but also policy help on issues of cybersecurity and rights in India. What I'm here to talk to you about, and I hope to use a little bit of this in the next around 20 minutes to 25 minutes to talk, but then to open it up to more robust Q&A, is to talk a bit about why should you care about law and policy regarding the work you do. And the first apology I make is that I'm very conscious of the definitions of different terms. So when people say cyber security, information security, digital security, and they say it means the same thing, I wince, and I assume you also wince, because infosec can be different from everything cyber, which is what politicians and lawyers often say. But I'm going to use them a bit interchangeably today to just talk about this sort of environment, not just that places such as the national capital in Delhi, but even elsewhere are having on your work. What are the top issues today that you should care about? Or as some people would say, when should you talk to a lawyer? When is it useful to know about the sort of work you do, assuming that you're a good actor, trying to create a more robust, effective, digital security and cybersecurity environment for everyone? What sort of structural things in terms of our current legal framework in India, or even the sort of ecosystems that exist, government institutions, not just the NCIIPC, which is one of the funders and active participants at this conference, but even other government agencies, how do they impact with your work? But what I think is more interesting, naturally, is that this is now March 2019. What happens in 2 to 3 months is the world's largest democratic franchise ever. It is the Indian general elections. And what happens at the end of that is July faces, you'll see a new parliament, in the sense of at least a new Lok Sabha, a new House of the People, and a government, either the current government coming back or a new government, whatever may be based on the franchise. But ultimately speaking, it's also a time when all these questions about law, policy get reset. You have an opportunity to talk about what would be the best thing for you. And I actually think I want to leave with that a bit and let your Q&As also go a bit more into what would be better for you. And of course, the first question you might have is, I don't care. None of this impacts me, right? If I, for example, doing penetration testing, if I'm doing, being able to do bug bounties or discover vulnerabilities, these sorts of things don't impact me. The reality, I think, for most folks in the cybersec and infosec communities is they already know it does impact them in some fashion. And why I always talk about these things is that as people discover things that vulnerabilities or issues that upset people, because naturally when you point out somebody's security infrastructure isn't as robust as it can be, a natural human reaction to sometimes is to just get upset rather than talk about what might be the best way to fix it. And then the challenge I think many of you have sometimes is that actually India's legal environment for InfoSec is a complicated one. And that's there in many countries, right? Many of you remember and are familiar with Aaron Schwartz, not just like a strong actor in the digital freedom and internet freedom communities, somebody who talked about democracy in the 21st century. Aaron was an activist, an information security person, a larger developer in the US, ultimately who was hounded by the US Federal Bureau of Investigation for accusations about having violated the US the US CFFA, Computer Fraud and Abuse Act. Now, the interesting thing is in India, your Information Technology Act already has a range of provisions that impact the everyday work you do. And I'm not going to be boring. I'm not going to do the lawyer thing and read out sections to you. I think that's the worst thing we can do ever. But what as a lawyer, I'll just flag to you is the reality is that you have provisions relating to hacking, which has a fairly broad definition in Indian law. And this is essentially anything that impacts information systems or a computer resource, to things relating specifically to the cybersecurity world sometimes. One, civil liabilities. And when I say civil, which is a term lawyers often use, civil literally means that instead of a criminal action where a police person or say a criminal magistrate subjects you to penalties and imprisonment, instead you have civil penalties. That means you have to pay money, damages, and if you don't pay those, you still go to jail, so it can be criminal as well. But basically that for anything that impacts sensitive personal information in this country, even under current Indian law, you already have issues in the sense of that there are requirements to respect anything which may result in the breach of sensitive personal information about body corporates. It's a very limited term, but that's already something that's there in India's IT Act under a section called 43A. You also have specific provisions and laws on things such as cyber terrorism, and that's a broad definition. And why I say this as a lawyer is I still struggle to understand what that means. Our parliament in its wisdom in 2008 passed that amendment to the IT Act to include that provision. And I'm sure some of you have strong views on what that should cover, but as you know, most lawyers say, it's unclear sometimes what all cyber terrorism covers. But also there are provisions to agencies to discuss and to study cyber incidents. Some of you are familiar with the work already done by India's CERT-in, the Computer Emergency Response Team, but other government agencies about essentially InfoSec incidents and their requirements to sometimes share information. And the question can be is what can they sometimes ask for you on that? Is that just say the metadata or transaction log about traffic, about in relation to a cyber incident? Is it something in relation to your tables or headers about what vulnerabilities might be there? Is it your full infrastructure or data about what's taking place, including your own source code or your own, the programs that you might have developed? It's fairly broad and overbroad, one would argue. What's also there is fairly strong provisions about what should be India's cybersecurity agencies itself. For example, the NCIIPC, which I mentioned previously, and many, I know staff and others are here from the NCIIPC, National Critical Information Infrastructure Protection Center. They are actually empowered by union law, that means law made by Parliament sitting there in Delhi, to be able to directly call for information and do a whole range of things, but also designate certain systems as critical information infrastructure or as protected systems. There are a range of systems, some of them central government, for example, the Central ID Repository of the UIDI, many other state government systems, some systems run by the military or national security that are designated as this, which means that there are additional, not just penalties, but also measures. For example, that there should be chief information security officers or other things appointed by these sorts of government agencies. And it's useful to know that. The challenge often in cybersecurity powers in India is that there are an entire range of agencies. I call it the alphabet soup, right? There's CERT-in, NCIIPC, NCCC, National Cybersecurity Coordination Center. There is a National Cyber Coordinator. There is MIT, the Ministry of Electronics and IT. There is the Department of Telecom, DOT. There's a CERT-T. So as you can see, lots and lots of acronyms. It's really, really fun and exciting, as you can imagine. But what these acronyms also indicate or betray is that there's a very complicated set of these institutions. And sometimes this stuff is confusing enough that the officials or even the parliamentarians or the lawyers who track all of this don't know what it necessarily means. And I'd be curious about your thoughts on that as well. What's also interesting to look at in terms of current law, but what's partly they're not there, is the debate are also around encryption. Some of you all may remember that now, in fact, I think 2 to 3 years ago, there was a draft encryption policy that was put out for public comment. Some of you who work on cryptology or on secure communications would also remember it was something that people were fairly concerned by because there were things such as plain text requirements. That means that if anything you encrypt, there'd also be a plain text version that either you would have to keep or potentially escrow with a government agency. There's unclear language about vulnerabilities being inserted. And obviously, you've seen the much more public, some slightly, I would say, no holds barred fight in the United States around Apple and the FBI and others as well. But we've had a very active conversation in India around what should this framework be. It was also so interesting because within 2 days of the government issuing that policy document, they withdrew it from consultation. It was a draft document. It wasn't final. It was just something that put out for comment. They were fairly worried about the comments already in the press over those 2 days. So much so that they said they would withdraw it, consult with people in this space, and then bring it back. And I'm curious, and I'm not sure anyone's hand's going to go up. Has anyone been consulted about the national encryption policy in this room? I'm assuming Chatham House rules, so I'm not going to disclose that you've been consulted. Anyone who's been consulted? No. The reason why I ask is because you're exactly the community that matters on this, right? It's not just me, it's not others in this space. It's the people who develop cryptology, who develop secure communications, who disclose vulnerabilities, who should be spoken to. And that's one more thing, that we right now don't have a national encryption policy, which for some people is a good thing. They say that perhaps government's not regulating it. For other people, especially ones who talk to lawyers, they tend to go, maybe no, maybe yes, because currently if you try to deploy bulk encryption in telecom networks, it's actually already illegal because it's been illegal for 20 years. The government clarified it to mean that bulk encryption on telecom networks doesn't always mean consumer side products. The messaging, communication apps or other sort of crypto that you deploy every day, that's, for example, a sort of like gray zone that a messaging system such as Signal or WhatsApp occupy, where they are on telecom networks, but they're not deployed by telcos, right? But the government already in India, again, under the Information Technology Act, can ask you to decrypt information. They can also set regulations for encryption. And what that means is today, for example, if you build a secure app or encryption system that's end-to-end encrypted, where you don't have the keys, the client has the keys, or maybe there are no keys, asymmetric, you may be forced to decrypt something that you can't decrypt. And like, that's a fun fact, right? What happens in that case? That goes to a judge, it goes to lawyers, but like, that's why we all go saying, look at each other, we don't know, it depends on the judge. And that may be of concern, right? That's one area. The other area is that they can set regulations to tell you today, don't develop encryption this way, or perhaps require key escrow. That's not something that has to go to parliament. They actually already have powers under the law as is. All it requires is for the government to issue regulations, which means that they're issued on something called the Gazette of India, a draft notification by ministry officials, which is provided, a copy is provided to parliament. Your parliamentarians can amend or perhaps vote it down later, but it's law from the very moment it's issued. And that's one interesting, important fact that's there. What's interesting and what's not there today is the privacy or data protection regime. Some of you who've been following this more closely know that India is very actively involved in this discussion debate. If you follow not just the Aadhaar case, but also followed general privacy, you know that the government of India, at least its lawyers in court, said there is no fundamental right to privacy after people challenged the Aadhaar program, saying that on privacy grounds, that is clarified by the Supreme Court to say that there is a fundamental right to privacy. The Supreme Court didn't say that they're creating a new right, by the way. They said it's always been there. They are clarifying what's there, that you have a fundamental right to privacy and it means this. And of course, as judges do, when they said it means this, they've actually increased the standards, which means that they've created a more robust right. But they said on things like data protection measures, on how government can store data, but even on things like surveillance, Parliament actually needs to fill in the blanks a bit, and it needs to pass a law on this issue. Our government, in fact, committed both in the Aadhaar hearings as well as in another set of hearings in the Supreme Court on WhatsApp and Facebook transferring data amongst themselves, that they will bring a data protection law. Some of you who may follow this more closely may know that the government of India actually they took public comments on what this law should look like. They asked a retired Supreme Court judge, a man called Justice B.N. Sri Krishna, perhaps more famous for some of you for the person who said that Chanda coaches should not have stock options. He's done other work as well. But Justice Sri Krishna issued a report that said that this is what a data protection law should look like. And you can ask me my views on that topic later on rating his report. But he came out with even a draft bill, and a bill that the government of India said they would take some more views on it and they would bring to Parliament. It's not been brought to Parliament so far. And as some of you also know, Parliament stopped sitting. Its budget session just finished. And more or less, our current Lok Sabha at least is at the end of its term. In a couple of days to perhaps maybe a week, 2 weeks, the Prime Minister will request the President to dissolve the Lok Sabha, which means that basically now post-elections is when a privacy or data protection law may come to Parliament, may not. What's interesting again is India is one of the few large democracies in the world, and I know there are many people here who work with different countries, jurisdictions, and markets here. India is one of the few countries in the world that actually does not have a clear federal data protection regime, with the exception of perhaps the more complicated one, which is the US, which doesn't have a clear federal data protection law, but it has some privacy standards. And it is the second largest internet user base in the world. It's ahead of the US, it's below China, but with no clear union government law on this topic. India is also one of the few countries globally aware on issues such as surveillance. And by surveillance here, I don't mean, say, our interception of communication of countries abroad, but of domestic surveillance. Say police having to tap somebody's phone because they're accused of committing a crime or potential local national security matter, or, for example, issues relating to political intelligence, which all governments do. In India, that is something which is done by civil servants, in the sense of civil servants issuing those orders, reviewed by civil servants in turn. It's not something that a judge ever sees, which is something, again, unique amongst many countries in the world, where there is very little oversight by either your elected politicians in parliament on what's happening on wiretapping or surveillance. There's also no oversight mostly by judges. You can technically go to a judge and challenge it, but the very fact of interception happening is secret, so it's a bit hard for you to get a lawyer who take that case on. But that's something that's also right now actually for the Indian Supreme Court. And there may be a hearing saying that India needs to improve these standards. But these are some of the things of what's there today. What I want to talk a bit with you is what really does 2019, 2020 look like. Encryption is very much in the air. As I said, we don't have an encryption policy document, but even today, even the last few days of this government, there's a proposal to require that existing Indian law, namely under the Information Technology Act, there is a provision that says that if you're an intermediary, that means, say, if you're an ISP, if you're a website platform, if you're a messaging service, if you're anything where you host third-party data, some of you, if you run, for example, a messaging service or a forum, you're also an internet intermediary. The government of currently, rather, Indian law says that you are not responsible for what your users do. So, for example, if I run a service and the gentleman sitting here sends a message to X gentleman saying, I plan to murder you, I'm not saying you do that, sir, but if you say that message, I am not, as a platform, directly liable for what he might be committing to do, unless I know what he was doing very clearly, or if the courts or the government comes to me and says, take this down. Some of you may remember the Shreya Singhal case, Section 66A, which is being used to target bloggers and activists. In that same judgment, the Indian Supreme Court said you must have this standard. It's important for free speech. Because if, for example, I am made criminally liable or civilly liable for everything that flows through my networks, many of you are courageous, brave people, but most company people are risk averse. They will say we'd rather censor everything, right? Now, the government of India today itself is suggesting that these rules, which allow platforms to do this, they're saying we're going to add some language there to make them a bit more responsible, a bit more socially accountable. And as part of that, they're saying that if you run a communication service, and of course, these are my words, I know government officials or others may differ in my interpretation of what they're proposing, but they're stating that we want to require an element of traceability. For example, that if you send a message, that we're able to trace what's going on there. They've been at pains to say this is not breaking encryption, but if you talk to people, look at it a bit more closely, in reality, it is that same principle. It is that they want to, for example, before you encrypt something end to end, they want to say, we want a hash stored of that you retain, which is data retention for some of you who follow that subject. It is information they may want you to introduce a vulnerability on, perhaps later. So it's a topic that's fairly controversial. Now, again, these are things they don't require Parliament to do. Ideally, they should go to Parliament. This is a feedback that many people have said, that you may have a valid point of view, but you should not do these by regulations, because regulations are driven just by our executive branch. They're not subject to automatic review. They can be reviewed later. But you shouldn't do this, especially you shouldn't do this in the last few days of this government. Let's see if those was issued or not. But that topic is very live. So even if they don't do a national encryption policy document, this discussion, this conversation that currently public officials and government officials are worried about encrypted messaging services is very much there. And I think that's something that for the InfoSec community to know, to think about. People may have different views, but it's something relevant for you to know. It's coming ahead there. And when in June and July, a new government or the current government comes back and a new Lok Sabha sits, this is very definitely a topic that is going to be before them. The other topic that I would suggest that you all should be asking proactively and considering is, actually, what is our national cybersecurity strategy? We have a document, one that was worked on by government officials. If you look at that cybersecurity document and you look at the alphabet soup, as I mentioned, of agencies today, they don't match. And obviously, things move fast. But sometimes you want a clear strategy, a vision of what your government is doing. Not just what it's doing domestically in terms of which agencies are doing what, but also what it's doing internationally. domestically, the one thing I would suggest, and I have a strong view, is if you ask what cybersecurity means to people, it means everything, right? It means cyber crime, it means digital security, it means proactive infosec, it means offensive military operations. I sometimes think that actually it's useful to separate these out a bit, because as sometimes people have said, the people who are going and trying to chase down criminals and threaten, say, X person or Y company for not giving data should perhaps be different from the same person who's going to companies or to developers like yourselves and saying, will you cooperate with us on incident response, on vulnerability disclosure? Or the classic US example, right? That the same agency that was conducting offensive surveillance operations, the National Security Agency, was the same one involved initially in conversations about vulnerabilities disclosure. And surprise, surprise, some of the vulnerabilities they received, they didn't want to pass on to others. And this is what I would say, forget your views on civil liberties. It's a bad policy outcome. Because, for example, if I have a doubt about sharing something that I'm facing, or if I'm worried that, look, at the Nalcon party, people are going to grab me and say, why did you cooperate with surveillance, man? That is something that's a bad policy outcome. It's a bad system that's being designed. And that's something we should consider. And what I'm suggesting is actually a really good time, and it sounds like a bureaucratic babu exercise, right? But it's a very good time to have a new, clear national cybersecurity strategy about where we're going, what do we want to do. The other reason why I suggest we need this is, as you know, cybersecurity is not a national issue, right? It's an international one. And one of the fundamental challenges you all see every day with your client base and everyone who you may work with, whether profit, non-profit, general stuff you discover or paid client work, is that this is global. And one of the challenges is that in fact, it's become a more militarized, frankly, even more government-driven space. Large government, firstly, what tools government have are already available to, say, organize crime or even unofficial actors today. This is something that is not my thought, by the way. It's not original. It's from my chief technologist at Access Now, a man, Gustav. And he pointed out what used to be only available to government 3-4 years ago is available today with organized crime units. This is what Kaspersky has also said in Flag. What governments used to have and do is increase multifold, because governments are actively targeting each other or encouraging their friends or hackers or universities or units at unknown establishments to conduct offensive operations. And in fact, what's happening in this is they are targeting the civilian infrastructure of the internet. That's something that some of you may have seen companies already responding to. Microsoft in particular, I know, has been very active about this. They publicly said that there should be earlier what they call a digital Geneva Convention. I can use the word Geneva Convention since now many of you are familiar with it, thanks to the Indian press. But the idea that during times of armed conflict and peace, certain things are not done or certain things are done, right? They want a similar thing in the tech space. There is a conversation today, in fact, a roadmap. It's called the Paris Roadmap on Cybersecurity and Cyber Peace, where lots of governments and even companies, even non-profits, my organization Access Now has also signed that, saying that we want governments to move towards saying there should be norms of cybersecurity or cyberspace behavior, not behavior in terms of what you post online, although some governments are asking for that, China and Russia included. But a lot of governments are saying that we want to say that, okay, even though we all conduct military operations, intelligence operations, we won't target certain things. We'll agree that certain things are off limits, at least for now, at least when armed conflict is not taking place. One of the challenges, for example, is we still don't know the Indian government's formal position on this. And they have different views, but I would suggest that it's good that that view is driven by even one conversation with you all, before even, say, open discussion with MPs in Delhi, because it needs to be driven by what you all think are India's cybersecurity, information security concerns. The most important thing is, as I mentioned previously, India is the world's second largest internet user base. Again, another fun fact, it's technically the world's most connected democracy, which I know can sound sometimes a bit off-putting given that we're still trying to drive broadband and fast internet for so many of our fellow citizens. But just by pure numbers today, world's most top connected country, China, definitely not a democracy, arguably. Second most connected country, India. And then the United States. And if you treat the European Union as a whole, perhaps the EU, but we don't look at it that way. Given that we're the world's perhaps most connected democracy, on cybersecurity, we also need to take very clear leadership about the sort of internet we want. That may not be a vision of cybersecurity similar to what the United States proposes. It may not be similar to what the European Union proposes, but it should be a clear cyber vision. And that's something that, again, should be driven out of what you all perhaps suggest and what you want today. And why I'm mentioning all of this is that it's sometimes easy to be passive, to say, like, look, I'm coding, I don't care. But the point is that policy is driven by people who show up, right? And policy is politics. Policy on cybersecurity is also driven by the sort of demands that come from people that take a vision. A couple of years ago, you would have asked anyone that, do you think Indian parliamentarians would say that they support something like network neutrality? They'd laugh. They'd say, no chance. And I can tell you, like, just 2 years ago, hearing a speech where in fact, a legislator from a regional party in Uttar Pradesh in Chast Hindi who was talking about why network neutrality is important. Non-discrimination is an issue that should not be applied at a technical layer, and saying they want remedy. Technical words that we sometimes find difficult to say in English being said in Chast Hindi before an audience that you would say, oh, they don't care about it, or they would never know. They already engaged on topics such as privacy. When people looked at the issue that do Indians have a fundamental right to privacy, and the case came out of the Supreme Court, one of the things they said was, there's no Hindi or Indian language translation of the word privacy. Nijta is more a reference to secrecy or confidentiality. Is there equivalent in, say, in Tamil, in Malayalam, in Bengali? Fun fact, after the right to privacy judgment, people voluntarily translated this into whatever is the closest word they have. As I said, I volunteer with the Internet Freedom Foundation. They just put out a post saying, here is the judgment. What would you call privacy in your subject? Can you translate privacy principles into your language? And I remember 25 volunteers, multiple languages jumped up and they did it. But that's again, it's a public thing that's pushed by what you view. And the other thing I often share with is my job at Access takes me across a large part of this region, looking at Asia Pacific public policy and tech policy. Other thing that we are unique in is that we are genuinely a democracy, a contested, active, sometimes dysfunctional one in some elements, but we are a democracy. What you say is something that will drive what civil servants or politicians do. And I want to leave that with you. I want to take questions, whether it's about what you face today, what you think we should go to. And even this is boring, even if you think this is a complete disconnect between the people who talk about tech policy and the sort of everyday things you see on cybersecurity, information security, or even the digital security business, happy to take that. I'll leave a few pictures at the end for you just to take a look. Visit accessnow.org. That's ACCESSNOW.org. If you're interested in any of the policy things I've said, we're an international nonprofit. We do stuff for free, so you can see what's there. But more importantly, if you work with journalists, if you work with activists, if you work with others who get targeted, the sort of people who make democracies function, not just in India, abroad, we run a digital security helpline, which is free. Anyone can reach out, and we have incident handlers who respond quick. We also open to people's thoughts and volunteering on these things all the time, but take a look. There's also a training, an entire media track that the great people here at Nalcon are doing tomorrow. So if you know people in the space who are relevant, even if it's short notice, tell them to drop by. Even if they don't drop by, there are guides, there are resources available. We're not the only organization on this. The Electronic Frontier Foundation, Eva and her team do great work. There are many others in India as well, the Software Freedom Law Center, the Free Software Movement of India, many other organizations who do great work there. Several groups who do great work about women and cybersecurity as well. See them. And if you're an Indian, one who cares deeply about civil liberties, about protecting your rights in court, in parliament, or in regulators, I encourage you to visit internetfreedom.in, which is the website for the Internet Freedom Foundation. Take a look, donate. It's supported by Indians like you who give regular donations every month, every day. But if you care about privacy and you want to know more about that, you can see the Save Our Privacy campaign. That is there at saveourprivacy.in. It's also available on the Internet Freedom Foundation's website. And I think that's important because if you look at how long it's taken for privacy law in India, it's been now 11 years since the discussion first started in Delhi that we should have a privacy and data protection law. It's going to be another 6 months. I'll be happy if it's another 6-7 months rather than another 5 years. So you should care about privacy as well, even if you don't agree with data protection, but I do. So happy to take questions.
Hi. So what's your view on right to erasure?
Right to erasure?
Yeah.
Yeah. So, and for people who are not familiar, like the right to erasure is like a data protection concept, although it's something much more complicated than that. But the right that if you, as a data subject or as a person who produces the data, it's made available by a data controller, you have the right to erase it, not just from the person who takes it originally, but even other parties. And in the European context, it's been connected to a more complicated but controversial thing called the right to be forgotten. And so my view is, I think you do have a right to erasure. You can delete information that's your information made available. If there's additional information added on top of that, or reportage, or say press freedom, I think there's a hard limit there, especially in India. Like we have a right to information, we have a right to free speech, certain things can be carried. I do think you have a right to request for your personal data to be erased. I think the challenge is that the right to be forgotten is not just that, it's also a right to de-index. And what that meant is, for example, the classic right to be forgotten case regarding Google, and I gave the disclosure, I used to work at Google, but I attack them all the time now. In the Google case in Spain, it was actually not the original newspaper that published the story that was targeted, it was Google. And they said Google should remove it and de-index it. That, both my team at Access, but many other lawyers, even privacy advocates in India, think is worrying, because firstly, you shouldn't go to private parties directly and request for it to be deleted. Although in Europe's case, it was a government agency that asked for it. You should perhaps go to the original data source first. So that's my view. There is a right to erasure under data protection law that can be subject to different countries' traditions. In India, we have a very robust view on free speech and information that may exist. A right to de-index should not exist. My other view is that a right to be forgotten, and whether it is a right to erasure, should not exist separately, as in like by courts creating it. It should come from a data protection law framework so you know exactly what it is. Why I mention this is in India, there are actually several cases before different state high courts where people have said that we have a right to be forgotten, and they've asked for public data to be deleted. So how many of you have ever heard of Indian Qanun? It's a free legal search engine that allows you to search for judgments that all the courts in India make publish. Fun fact, people have gone and said, there's this court judgment with granular details about my dispute. It's causing me disrepute. It's a great Indian word, right? Like causing me disrepute. I want it taken down. They don't go to the court, which is one that published it, where you can go, by the way, and say, don't publish a judgment. They have gone to Indian Qanun on Google saying, no, because of you, this is more easily accessible, we want it taken down. And that's where I think that's like a bad standard.
So apart from all these news items like right to forget or right to erasure, people can also ask to delete the logs, right? Logs, whatever they have done. So when someone does something bad and he applies right to erasure, then how does it bring that person to justice if he's done anything wrong?
So a couple of different things. I think one is that, of course, log stuff can be different levels of logs and other stuff, right? Like one is, are you keeping a log generally because, say, you're an entity and you want to know who's doing what, versus, say, the police requesting for log information or metadata or transaction things, IP addresses, pardon me, when you upload content. Now, firstly, of course, the reality is if law enforcement requests for data to be kept, what's called a retention request or a preservation request, that's a more technical term. India, often police use different terms for it. That would obviously override a direct, say, personal data protection thing on erasure.
Yeah, but
what if I go and delete it proactively?
Yeah, when the law asks for you to preserve, then you can do. But if the erasure request comes before, then you are erasing. There's no evidence for that thing, right?
Yeah, so what will happen is, one is because it's your personal information, right? In reality, police often don't need just personal information. They will have log data. Log data won't always be personal information. It might be, say,
in some log data, say IP address, your browser data, we can term it as a personal data, right? It can be used to identify you.
Yeah, so if you come with it proactively, very often, even in the current frameworks in other countries, firstly, it is you have to justify often why you're requesting or deleting that. And the fact that you requested it being deleted is a fact. So why I'm saying this is for police and again lawyers, so I have sometimes dealt with police officials as well. They would point out, if somebody came and made a right to erasure request for data we need for investigation and we uncover that fact, that is a suspicious and clearly potentially incriminating fact. So again, this is not legal advice, but fun fact, do not make an erasure request for something that you want removed, because that is, it's a Streisand effect, right? The Streisand effect says that if you say something is censored, people will get more interested in it. Same thing, if you come to a company and say, remove this, that's available. Agreed, it can cause law enforcement issues and all of that, but it's also like the healthy tension, right? If you store everything forever, it could potentially help surveil everyone. It could also lead to more hacking. It could also lead to, say, more identity theft. So that's the sort of like balancing act that, say, an MP or even a minister has to make, saying, police are telling me if I had this log data, they could find X person. The information security person is telling me if this log data is stored forever, it's also a great source of a honeypot for somebody else to come and attack. Not necessarily a honeypot, it's a treasure trove. So that's the sort of tensions we have to manage there.
Hi, this is Tanay. Regarding a data localization bill that's supposed to come up very soon, hopefully. So I just want to have an understanding about data categorization. Like there is a talk about critical data and non-critical data. And if I'm not wrong, critical data you need to be here within country, and non-critical data, a copy of that has to reside here and can go out. That is my understanding. Correct me if I'm wrong. So in a given situation like this, most of these international bodies are claiming that they are going to host their infrastructure here within India. where they will host all those data, which comply with the proposed law. Now, given a situation where everything is so connected, everything is global, how do you ensure that even if they claim that there is no chance of, copying the data outside? I mean, who is responsible for those checks and balances once it is implemented? That's number one question. Number two is, there are countries who have bilateral agreement of not targeting their IPR setup. For example, US-China has relations like that. So do you think that we also should go in that direction of having bilateral relation, because nation states are targeting each other, their critical infrastructure? So what's your take on that point? Thank you.
And just a quick question: how many people know what data localization is? So I think I should explain it very quickly for those who don't. Data localization is the idea of the proposal that's put across by some governments and by some parts of the Indian government now, that data produced by users in a particular country should be localized on servers, infrastructure, or entities registered in that country. Meaning, for example, that if you're an Indian citizen, your data can only be kept in a data center here in India, or perhaps by an Indian company, and should not go, if it goes abroad, it needs to be kept in some other manner. Now, a couple of things, and those are you have clearly read the provision in the proposed data protection bill, so congratulations, sir. And I want to address the question of what you said of how it's possible. Rather, how would it work? Now, I think the challenges are that it's not clear how that would work. And I think it's worthwhile also talking about whether it's worthwhile in the first place. But I'll come to my view on that in a second. The first question about how it would work right now is not fully clear, because you said, you're correct, absolutely, that the law proposes, and remember, this is a draft bill, it's not even a government draft bill, it's a expert committee giving it to government, the government has to decide, cabinet approves, notionally goes to parliament finally decides. So there are many things before the final cake comes out. But, in this... I'm just coming that, sir. No, I'll just come. So I know that what I was going to say was that in addition to the general data localization proposal, there are specific proposals regarding, not proposals, existing regulations on financial payments. And just to go, it's under the financial payments, instrument system and payment gateways and what's kept there. Absolutely. RBI did that. RBI is also famous for quickly issuing regulations and with very little public comment. And RBI believes it doesn't need to go to parliament because it's a regulation under an existing act. So, absolutely taken on board. There's existing data localization on financial information. There's a proposed general data localization requirement. Sorry, I said data protection. I mean data localization on financial, general data localization proposed, and other things about national security or others. Now, the challenge is that the current Sri Krishna draft bill on data protection proposes a general data localization requirement and tries to then say it might be government notifying what's critical, what's not. The law doesn't do that, which is problematic because you don't know what that means. You would also, if you let the government designate it, notionally Parliament reviews it. A copy is what you call tabled on the floor of the Lok Sabha, floor of the Rajya Sabha. Now, if an MP wants to cancel that, they have to get both houses to vote against the government, which is a very rare fact. Again, that's a challenge. Some people say if you're going to designate critical information, let Parliament decide what's critical, what's not critical. It's also not clear whether that's a military or economic, criteria or other things. In other countries, for example, in the US partially, there's the Federal Information Security Management Act, FISMA, that allows certifications, and then federal agencies, including the most sensitive ones, their data can't go outside borders under level of FISMA certification. Now, my view is that data localization, to be honest, can work in special, very clear, critical situations on national security. For example, like, if you're a military agency, or even if it's military data held by a third party, perhaps that should not cross borders easily. It could be also so that financial data, you keep a log of it here, but you maybe share multiple versions elsewhere. If you were to ask a privacy and data protection person, is data localization good for data protection? The answer is no. Data localization does not always guarantee, in fact, strong data protection. Data protection in itself does have ideas that, for example, if data crosses borders, imagine today if India had a legal regime just like the European Union's, hypothetically. What that would mean is that if when Indian data is taken to another country, you could request your data protection regulator in India saying that country doesn't have the same level of data protection as us, prevent it from happening or ensure there's either a contract, many of you signed binding contractual rules, right, or now model contracts, or that the Indian government convincing that government to do what's called create an adequate legal regime, which is what the European Union does. It goes and convinces other governments, can you ensure that you're protecting data at the same level we are, or at least our citizens, do they have a remedy in your country on data protection? Most recently, the European Union did this for Japan, where they said the Japanese government has both updated and modernized its data protection law. Our countries are at the same level. Let us sign a handshake. Data can flow between our countries without having to do all this legalese or looking at data transfer. I think data protection is a better way to go than data localization, with a few perhaps exceptions on mirror copies or whatever in situations. So I know that's not a full answer to what you were saying there. Your second question, and correct me if I'm wrong, I'm just trying to remember, was on IP and like these things. So I think that's important to separate sometimes intellectual property theft, which I know is what the US used, although it was referring to cyber incidents. But I do think there's benefits for bilateral agreements and others to say we will not target each other's infrastructure. The only thing is that we need to, in addition to these like one-to-one agreements, India, by the way, doesn't have agreements yet, but we do have cyber dialogues or even cyber security resolutions with other countries. We have one with the US. We have a regular dialogue discussion with Australia, with Japan, India, and ASEAN. The ASEAN like member bloc have agreed to things as well. Those are good things. But we do need an international or even maybe a multilateral, like means many countries together committing that we will not target each other's civilian infrastructure, at least perhaps, or that laws of war which already apply to cybersecurity, we categorically commit we do that. Unless we do that, these bilateral talks can be dangerous also, because other countries can do that and our interests may not be protected there. So that's the danger. Especially the US, for example, hypothetically would go to every other major country and say, this is what we're doing. And then India is under pressure to do that. So that's the sort of danger of these one-to-one talks. But yes, a one-to-one discussion is better than nothing at all, for sure. Why I mentioned this is, again, the UN is discussing this very topic. It's something very technical, but it's something called the Group on Governmental Experts on Cybersecurity. In fact, Dr. Gulshan Rai of India was once on that group as well. They are trying to produce a report, a standard on cybersecurity again, and this sort of offensive cyber operations, what should happen, not happen. So that's something actually where we need to articulate a stronger position, in my view. One question here. On the back.
Sorry, so I was just wondering if you would outline the stakeholders that are involved when it comes to online privacy of individuals and what their responsibilities could possibly be.
And so it's a wide ecosystem. I'll talk about what could be, but what is today in India specifically. They are you, the data subject or data creator, however you want to define it. I refer to the term citizen because most of your citizens are Indian residents at least. And you have a right to privacy under the Constitution. You have current rights under the ITI Section 43A provision on sensitive personal data. Unfortunately, you don't really have a right as much as you have a right to claim damages if a body corporate misuses your data and if you can show harm. Now, these are many, many hoops to jump through. How many major court judgments or government orders have you heard about data being breached in India? Because the legal framework doesn't really allow them to do that. What right now is, if you want to say claim your right, you'll have to go and ask in your state, has a controller been appointed under this provision? Or you go to Delhi to the union government, ask them to do that. That normally then goes to a cyber appellate tribunal, which in fact stopped sitting because there was no judge appointed to head it. And now it's been merged with another body, so nobody knows if it exists, which is where even the Indian Supreme Court has basically said that it doesn't exist. Indian citizens don't really have a right to remedy on data protection right now. So if you were to request it, you can ask your government to do it. For example, in Cambridge Analytica, Facebook disclosed that 500,000 Indian users' data was impacted. The Indian government acknowledged this fact as well, and in fact said, we are looking at it, we'll take issue. The only fact what they've done today is the Central Bureau of Investigation, CBI, has been asked to investigate it. I don't know whether they're talking to foreign governments, particularly to the UK data protection regulator. That's not happened. So what we do need, I think in an ideal world, is you want like data subjects or data citizens, however you call it, data controllers, those who collect the data and who may also give it to third parties or others. They're all covered under that, and they're all told what their rights and responsibilities are. And being honest also, many of you in this room would be treated as that as well. If you're running a business or collecting data or doing marketing, you'd be listed there. And then this is held accountable by a data protection authority or a privacy commissioner, independent regulator set up by law, not controlled by government, although it may have government servants there, where you can go and complain, or you can go and complain in Indian courts. Even today, you can go to Indian courts and complain on this. it's generally hard to establish a full remedy. And in fact, over the next 6 months to 9 months, most judges will say they're waiting to see what Parliament is doing. But they might even say Parliament's not moving fast enough, we'll give you a right. But you have that limited right there. What you also, of course, have is that many of you sometimes can claim remedy by going to European data protection authorities, because if you've traveled there or others, you all in fact have rights. It's not just citizenship based, it's sometimes based on residency. If you stay long enough in the European Union or the UK, you can claim that. So that's also there. Why I find that funny is most things on data protection today, even data breaches, are normally because of pressure from the European Union's privacy bodies or the US's Federal Trade Commission. That's when you get to know it here. Less so from Indian government authorities. So I don't know if that answered your question fully, but I think these are the sort of ecosystem you need to build.
Raman, we are over time now. We can take questions offline.
Thank you.